Hello, everyone, and welcome to this Privacy Rules Privacy Espresso. Today, we are at the second episode of our series on the Medibank case that was a data breach happening in Australia. We have been discussing it under the cybersecurity perspective in our first episode. Today, we are going to address it under the legal perspective, and we are going to do so with Kelly Dickson from the law firm Macpherson Kelley in Australia. So, hi, Kelly, and thanks a lot for being with us today.
Hello, it's good to be here.
Okay, Kelly. So let's go straight to the questions of today. And my first one would be, let's start from an actual overview. So what's the status of the Medibank case today?
Yes, I thought it would be a good idea to give an overview of where the Medibank case is up to. It has happened here in Australia, so it is happening to people that I know, and there's a lot of media that has been about this case as well. So this actually started in October. The hack incident first came to light in October of this year, but it is not anywhere near over yet. It is over from the perspective of the incident has happened, all of the media frenzy has happened, the reporting has happened, but now we're getting more into the legal perspectives of this case and what we will see playing out. So the first thing from the legal perspective is a formal representative complaint has now been made to the federal privacy regulator, the OAIC here, and the OAIC has been asked to investigate the case with a view to ordering some penalties and some compensation for the nearly 10 million affected individuals in Australia. And so the OAIC will be investigating whether Medibank took reasonable steps to protect the data and reasonable steps to implement procedures and practices, which is the requirement here in Australia. There also is class action relief that is being sought by two law firms here at the moment.
Okay, that's extremely interesting. Thanks a lot for this quick introduction on the stage. What about the ransom?
Yes. Well, I think that the ransom can often be a very controversial thing to talk about. The ransom that Medibank was requested to pay is estimated at about 15 million Australian dollars. The Australian government's positioning is to not pay ransoms, and Medibank did not pay the ransom. So it's controversial because some people say you should pay a ransom to get the data back and to maybe decrease the consequences that might happen for affected individuals. But some say don't pay the ransom because it's often quite useless anyway. A recent survey suggested that out of about 46% of businesses that paid the ransom, only 4% got their data back in a useful and meaningful and unencrypted way. So they didn't pay the ransom, and whether that has hurt more or not, there'll be different opinions on that.
Okay, that's also sounds very interesting and good to know, in particular because you're giving us also some numbers. So there will be I understand that the company will be checked under the technical and legal perspective to see if everything was done in the right way. Of course, under the ransom perspective, we know that they have been acting in the right way, at least legally. But of course, this doesn't mean that everything is solved, but at the same time probably there is a push for not paying ransom, otherwise we will see more and more ransom. So of course I
And
understand
it might
why.
encourage it. Yeah.
Yeah, exactly,
Yeah.
so I definitely understand why there is a push to not do that. But just one last quick question, Kelly, is related to the costs of data breaches like these. So are there some consideration that you would like to share with us in relation to this point?
Absolutely. And I think that some of the costs to businesses like Medibank are quite negative. From a business perspective, there's the ransom, whether a business will pay or not pay the ransom and that amount of money. There's also issues for a business with their reputation and the trust that their customers and consumers have and how they recover from that as well. That can be a very costly exercise. For a business like Medibank that trades on the stock exchange, this data incident also caused a trading halt on their stocks, on their shares. And sometimes businesses will also have mandatory disclosures to make to their investors as well. There's been a lot of negative publicity too, and a lot of resources that have been needed to direct the call centre and the remediation actions that Medibank has had to take. From an emotional perspective, lots and lots of affected individuals have lost faith. They've lost trust. They've been very anxious and very distressed as well. Some people have even apprehended physical danger, actual bodily danger as well. The financial cost, some people say that Medibank has already spent about $30 million in terms of remediation and trying to fix their systems and the data problems, but there probably is more to come for that as well. And there will be the potential for fines and penalties and compensation orders through that investigation by the OAIC. We don't really know what the cost of that will be. Some people are saying hundreds of millions of dollars, maybe 700 million, maybe 900 million. But here in Australia, we have never had any penalties that have been close to that. So particularly, it will be interesting to see where that actually lands in the next couple of months. But I think that there's also something really proactive in terms of cost as well. So despite these negative things, as Charlotte was saying on our last Privacy Espresso, there is a need to invest in technical solutions. And we are in a time and an age where businesses need to invest. So businesses need to consider privacy, compliance, and data protection in all of the jurisdictions that they operate in, whether it's in Australia, whether it's overseas. Businesses need to be proactive and, as Charlotte said, have that playbook for a data breach response and having that mechanism in place. And of course, having specialist experts on board as well. So IT experts, cybersecurity experts, lawyers like us who can assist with the legal and the regulatory side of things. And that is exactly what we and all of the other members of PrivacyRules can provide right around the world when there is a data incident that occurs.
Absolutely. Impressive numbers, very interesting points, totally shared, of course, also from our side. That's exactly what we are trying to do. In most of the cases, I would say that probably having a plan ready to go when the breach happens is the only way to limit the damages and the costs of a data breach. Also, not just because you are ready to act and react, limiting the cost of the activities that comes after the breach, but also because you have already something in place that you can show to the authority to say, I was compliant and I did everything I have to do. Then of course no one can really avoid an hack attack at the 100% of insurance, let's say. So we all know that, but being prepared already is probably the only way to limit this. And then otherwise there is the risk of taking the risk to pay the ransom, but you never know, as you were rightly saying, what you're going to have back, and if the authority is going to be happy with that. Probably not, I would say. So not the best thing to do. So absolutely, thanks a lot, Kelley, for being with us and for giving us this overview on the case under the legal perspective. Thanks to all our listeners for being with us today, and I look forward to meeting you all for the next episode of the Privacy Espresso. Bye everyone, and bye Kelley again.